Order at this point. I'd like to start off with the game plan for how we're going to proceed today. We're starting with our regular calendar of business. We take things in file order with an occasional shift depending upon a variety of different factors, but hopefully we will be able to proceed. But at 3 o'clock, we are going to have a special order, and we will be hearing SB 251 by Senator Roth at that time. That is the Civil Rights Disability Access Bill. And we will turn our attention to that issue at 3 o'clock. So we will take items up until then and then remove that item and take it up. And then we will go back to any remaining items that are on the calendar. Given the fact that we have 23 items, I suspect we will be here after we hear item number 3. That being said, we do have 6 items on consent. So the following items are subject to the consent calendar. And if you're here on any of those items, please feel free to leave unless you find this so fascinating that you'd just like to stick around. The 6 items are item 7, which is SB 363 by Senator Morell. Item 8, SB 383 by Senator Wieckowski. Item 10, SB 386 by Senator Allen. Item 12, SB 419 by Senator McGuire. Item 13, 421 by Senator Hancock. And item 20, SB 711 by Senator Wolk. Those matters are currently on the consent calendar. We do have 2 additional items that have been pulled by the authors. Those are file item 1 by Senator Hertzberg, SB 155, and file item 4, SB 262 by Senator Galgiani. Those will not be heard today. So out of the 23, we have 8 that have been pulled. That still leaves us with a hefty afternoon's worth of activities. The rules today will be for each bill, there'll be 2 main witnesses, 2 minutes each for support, and similarly 2 main witnesses, 2 minutes each for opposition. After we hear the support positions, I'll call those who have a position in support of the measure to come up. Hopefully we'll have ways for them, if we have a number of people, for them to just stand up at the sides there, give their name, their affiliation, and their indication of support. We'll then do the same thing with the opposition. That will move us along, so we will hopefully be out of here before too late this evening. And with that said, we, I believe, have a quorum, so Madam Secretary, please call the roll.
Jackson?
Here.
Jackson here. Morlock? Morlock here. Anderson? Present. Anderson here. Hertzberg? Leno? Here. Leno here. Monning? Wieckowski? Here. Wieckowski here.
All right, we do have a quorum. So let's start. We have Senator Hancock here. She has file item number 2, Elder Abuse Protective Orders. Good afternoon, Senator.
Good afternoon, Madam Chair and members of the committee, some of whom I've seen all morning, but yes, not you, Senator Wieckowski. Let me start by accepting as author's amendments, the amendments outlined in the analysis on comment number 5, page 9. I think that you have a mock-up, or you certainly have it there in the analysis. I want to really thank the committee staff and working with my staff and the sponsors in crafting this to be a very narrow bill, and it will essentially clarify current law relating to who is authorized to obtain a protective order on behalf of an elder or a dependent adult. Current law authorizes a protective restraining order may be initiated by the victim, or a petition may be brought on behalf of an abused elder or dependent adult by a conservator, a trustee of the elder or dependent adult, an attorney in fact who acts within the authority of the power of attorney, and a person appointed as a guardian ad litem, Or the language says another person legally authorized to seek such relief. There's a question regarding who qualifies as another person legally authorized to seek such relief. In fact, counties realized they weren't sure, and it was being inconsistently interpreted as to whether or not adult protective services are legally authorized to seek such relief. When it was recognized that the code needed to be clarified, we also know that there are many procedures in place and did not want to give just blanket authorization to adult protective services, especially if there was an elder or dependent adult who did not want to seek such an order. So this bill was developed to create the narrow ability for adult protective services agencies to file a petition while a conservator is being sought. But there is a need to step in and stop abuse in the most egregious cases while the fairly lengthy process of establishing a conservatorship is decided. So SB 196 authorizes a county adult protective services agency to file a petition for a protective order on behalf of an elder or dependent adult in the following narrow circumstances. If there is reason to believe that an elder or dependent adult is in imminent danger of becoming a victim of a crime and has an impaired ability to understand the circumstances or risk of harm, if the elder or dependent adult has suffered abuse and has an impaired ability to understand the circumstance, or if they have, in fact, provided written authorization to the Adult Protective Service Agency to act on their behalf. To ensure due process, an agency filing a petition would obviously be required to alert the adult and make reasonable efforts to have them attend the hearing. They would also have to have made or be making a referral for conservatorship. So this is a voluntary, has always been a voluntary program. We're not trying to change that. We're trying to open a door to prevent some abuses that have happened in spite of the law. So the bill will also require the Adult Protective Service Agency to take reasonable steps to provide for the safety of the elder, including locating alternative accommodations as needed, and to protect their remaining financial assets if financial abuse is one of the problems. As always, the court will review, and approve or deny any petition. So again, SB 196 will only apply when an elder asks for assistance or when the agency is confident enough that the individual has impaired ability to understand the harm he or she is in and a conservator is being sought. So with me today are Kathy Senderling McDonald with the County Welfare Directors Association and Mike McConnell, Regional Manager of Adult Protective Services in Riverside County.
Thank you very much. First witness. Good
Thank you,
afternoon.
Madam Chair and members. Good afternoon. Kathy Senderling McDonald with the County Welfare Directors Association. We're the sponsor of the legislation. And we also really want to thank your staff for working so closely with us over the last couple of weeks to clarify and flesh out the bill to ensure that the procedures that Senator Hancock was laying out for you are clearly spelled out in the legislation. The goal of the legislation is to fill a gap that county adult protective services agencies have identified when the individual that they're attempting to help is so impaired that we know we're making a referral to the conservator. That is in process, it's already been done, or we're about to do it, and we need to file for a restraining order to try to stop the abuse while that conservatorship process is playing out. Time is really of the essence in these cases. The abuse may be physical, it may be financial, it can be both. And the checks and balances that we've written into the bill, the court procedure that needs to take place, the conservatorship filing that needs to happen at the same time or just before the petition filed, and then making sure that the due process is there to notify the person and make the effort to bring them, if we can, to the actual hearing themselves, to work with them. And then finally, to ensure that we're not just, as APS, parachuting in, filing the petition, and then leaving again. The bill now very clearly indicates that our current duties under law to ensure that the person is safe and protected would then also kick in once that petition is granted. This is another tool in the toolkit for APS. It's intended to be narrowly used only in the most egregious cases where if the abuse were to continue while we're seeking the conservatorship, things will only get worse. It will be much more of a dire situation for the individual who's being abused, either a physical issue, a neglectful issue, or a financial issue, or sometimes all three. For those reasons, we urge your support. Thank you for your consideration. And I'd like to turn it over to Mr. McConnell from Riverside County to talk a little bit about the on-the-ground experience.
Thank you very much. Mr. McConnell?
Yes, good afternoon, Madam Chair, members. I'm here to tell you a little bit about where this bill came from and give you an idea of a case where it would be useful. In Riverside County, we have multidisciplinary teams made up of 15 different government agencies and organizations that work with elders and dependent adults on cases and issues of abuse. We have 90 different members that meet monthly in 3 different parts of the county. When we asked them what their legislative priority was, this is the idea that came out of those groups. So it's not an APS-driven idea, and we had very strong support from our District Attorneys Association. I want to tell you about Edna. She's 74. She lives with her daughter and her son-in-law. They have no source of income. Edna suffers from dementia. Her income is a small pension and Social Security. When there was a problem with her Social Security, her daughter and son-in-law took her to the local office where an eyewitness saw the son-in-law push Edna to the ground and kick her several times. Her daughter already has a prior conviction of elder abuse against Edna. However, she would not allow us access to Edna to check on her condition. While we're waiting for conservatorship and for the criminal investigation, which could take weeks, we currently have no ability to get protective orders for Edna. SB 196 would allow us to do that.
Thank you very much. Appreciate your testimony. And at this point, if we could have those additional witnesses in support, please just give your name, affiliation, and obviously at this point, your support for the bill.
Greg Niger with the ARC and United Cerebral Palsy California Collaboration. We support the bill, and we hope it eventually will be possible to get rid of that awful term dependent adult and replace it with what it means, adults with disabilities.
Thank you very much. Next witness.
Hi, Mike Montgomery, Congress of California Seniors. The Congress of California Seniors very much opposes elder abuse, therefore we very much support this bill. Please vote aye.
Thank you very much. Still dulcet tones. Thank you.
Hard to follow. I'm Farrah McDade-Ting with the California State Association of Counties in support.
Thank you.
Madam Chair, members, Julie Navoris on behalf of the Urban Counties Caucus, also here in support.
Thank you very much.
Good morning, Madam Chair. Tom Sheehy with the California Police Chiefs Association. Glad to support SB 196 today. Thank you.
Appreciate it. Thank you.
John Lovell, California Narcotic Officers Association, California College and University Police Chiefs Association, in support.
Thank you very much. Witnesses in opposition? Is there any opposition? If they'd step forward. Any witnesses in opposition? All right, we have a motion. Before we do that, though, any questions from members on this bill? Well, Senator, I think you've done quite a fine job here addressing a very, very serious problem that we're having. I'm not even sure the courts have the full capacity to address these issues, but certainly they are a serious problem, and as our society continues to age and we have more elders who are dependent on others for assistance, we need to do everything we can to make sure that our legal system can accommodate when those things go awry. And so I think your bill does that, and unless there are any other questions, we have a motion by Senator Wojciechowski. Would you like to close?
I think you said it very well. Thank you. I would ask for your aye vote respectfully.
Thank you. Please call the roll. This is due pass as amended to the Senate floor.
Jackson?
Aye.
Jackson, aye. Morlock? Morlock, aye. Anderson? Aye. Anderson, aye. Hertzberg? Aye. Hertzberg, aye. Leno? Aye. Leno, aye. Monning? Aye. Monning, aye. Wojciechowski?
Aye.
Wojciechowski, aye. 7-0, who's out?
All right. 1 second. Let me announce the call. 7-0. The bill is out. Senator Wojciechowski?
If it is appropriate, I'd like to move the consent calendar.
Well, we could certainly do that. We have a full house. That makes sense.
So move.
Why don't we go ahead and call the consent calendar? Everyone's aware of what is on the consent calendar? All right. We have file items 7, 8, 10, 12, 13, and 20. All right. Without further ado, Madam Secretary, please call the consent calendar.
Jackson?
Aye.
Jackson, aye. Morlock? Morlock, aye. Anderson? Anderson, aye. Hertzberg? Hertzberg, aye. Leno? Leno, aye. Monning? Monning, aye. Wojciechowski? Wojciechowski, aye.
7-0, the consent calendar is adopted. We now have file item 5, which is Senator Hueso. Senator Galgiani pulled file item 4, so we're up to file item 5, SB 287. Would you like to proceed?
Madam Chair, at your discretion, I'm yielding to the doctor. It says his bill will take a few minutes.
All right, well, if that's your wish, I will certainly accommodate that. That's going to probably cost Dr. Pan some major points, but we will go to Dr. Pan's item, which is file item 17.
Yes.
Good afternoon.
Thank you. Thank you, Madam Chair, members. I present to you SB 600, a measure that will amend the Jesse Unruh Civil Rights Act of 1959 to outlaw discrimination on the basis of citizenship, immigration status, and language. California leads the country in innovation and diversity thanks to our 10 million immigrants who make up 30% of our state's population, the largest in the United States. And these Californians are vital for helping our economy flourish in all sectors, contributing 31% of the California's GDP, which amounts to $650 billion annually. California is also the most, it leads the country in the diversity of its immigrant status, with 50% of California's immigrants are naturalized citizens, and another 26% have some other legal status. California is the most linguistically diverse state with 207 languages spoken by over 40% of Californians. Our immigrants are family members, neighbors, friends, colleagues, and loved ones. Unfortunately, these Californians are the most vulnerable to discrimination, hate crimes, and unequal access to the most basic daily functions, such as eating in restaurants with their family. Among verified cases of discrimination are instances where persons were denied service or asked to leave establishments because they were conversing with companions in a foreign language. Other examples include laborers barred from establishments near where they congregate, persons denied entrance to entertainment venues or denied service when they provide proof of age with a foreign passport, foreign government-issued identification card, and radio and other business contacts that restrict participants and winners to quote-unquote legal residence. While these individual occurrences may seem trivial to some, they all reinforce an awful atmosphere of discrimination and unequal access when it comes to services which should not be tolerated by any Californian. There are not many filed court cases challenging discrimination on the basis of citizenship, immigration status, and language because these forms of discrimination are not illegal and because these discriminatory acts target those less likely to understand their rights or to less likely to assert their rights out of fear of unforeseen consequences for themselves or family members. We must protect our most vulnerable Californians as they stand up against discrimination and public accommodations and hate of any kind. SB 600 addresses the ongoing discrimination against our immigrants in California. In doing so, our immigrants who are key to California's success and strength, but who are among our most vulnerable, share the same civil rights protections as all Californians. And I have witnesses in support. Thank you.
Good afternoon. My name is Denise Hewlett, and I am National Senior Counsel for the Mexican American Legal Defense and Educational Fund. Clear and understandable law in the area of discrimination on the basis of citizenship, immigration status, and language is important not only for the vulnerable populations that experience discrimination, but also for the businesses who are required to comply with the law. The state of the law is such that the business owners currently could conclude that policies based on those characteristics are allowable under the UNRU Act. Now, it's true that the courts interpret the UNRU Act very broadly, and although MALDEF would argue in favor of a construction of the Act that would apply it to those characteristics, the characteristics are not specifically in the statute, and therefore they don't give clear notice to business owners who want to ensure that they're not subjected to liability under the Act. That kind of notice simply won't be found in the case law. When courts have recognized categories that are not explicit in the UNRU Act, they've done so in recognition that the categories were based on personal attributes largely immutable, so long as the additional characteristics are similar to the ones in the Act. Now, we can certainly argue whether immigration status, citizenship, and language are so immutable and similar to national origin that the court would consider bias imposed on those bases to be prohibited, even though it's not listed in the statute. But with these three characteristics, which are theoretically changeable, be therefore construed like the economic distinctions that were rejected in the Harris case, or like the immutable characteristics that are already in the statute. Rather than ask business owners to establish their policies based on a prediction as to what a court might do and might hold them liable for in categories not explicitly listed, this legislation gives clear guidance to businesses about what exactly is an unlawful discriminatory practice. MALDEF urges your aye vote. Thank you.
Thank you very much. Let's hear the full, and then Senator Hertzberg has a question for you, which we'll get to as soon as we go through those all in support. We'll have any questions you might have. This is an interesting discussion. Sir.
Sure. My name is Luis Ojeda. I'm the statewide coordinator with the California Immigrant Youth Justice Alliance. I am undocumented. I did have the benefit of benefiting from DACA, and so I am a DACA recipient, but unfortunately, many members of our community aren't as fortunate. And I myself have witnessed how I was discriminated myself through the use of a Mexican passport or a Mexican matricula. There are members across the state that have experienced similar discrimination, where there are several private businesses that don't accept that as a form of identification. And given that a lot of our members don't have other forms of identification because they don't qualify for deferred action or other forms of legalizing their status, they have been, unfortunately, unable to patron those businesses. And so, I think for us, this is a major issue. And what we see here is an opportunity for California to really lead the way, to really show that all Californians, including undocumented Californians, are valuable citizens, and they should be protected under the law against discrimination on the basis of citizenship, language, or immigration status. And so I urge also support of this bill.
Thank you very much. Other witnesses in support, if you just step forward with your name, affiliation, and indication of support.
Yes, Ronald Coleman here on behalf of the California Immigrant Policy Center, also here in very strong support. Thank you.
Thank you.
Lema Murtaza on behalf of Asian Americans Advancing Justice Sacramento in strong support. Thank you.
Thank you.
Hi, Joseph Vigela with CHIRLA, the Coalition for Humane Migrant Rights in Los Angeles, also strong support.
Thank you.
Jackie Sarananquiano on behalf of the Consumer Attorneys of California in support. Thank you.
Thank you.
Deborah Carlton with the California Apartment Association in support.
Thank you very much.
Jeanette Sonny-Patin on behalf of MALDEF. We are a co-chair of the California Civil Rights Coalition. We are a strong support and sponsor of this bill. Thank you.
Thank you. Any witness, Senator Hertzberg, you wanted to ask any other witnesses in support? All right, Senator Hertzberg.
Just very quickly, just for full disclosure, I used to serve on the board of MALDEF, but doesn't mean we can't ask each other good questions. I worked my first case on arbitrary and invidious discrimination for the Unruh Civil Rights Act, Civil Code Section 51, as I was explaining to Senator Leno, if my recollection is correct. But how do you determine, if someone's in a restaurant speaking another language or whatever the case may be, you don't want certainly discriminatory behaviors, no question, I agree with you. It's a lawyer question in the Judiciary Committee. How do you determine someone's legal status, right? I mean, we have this notion of national origin that has been litigated, we know, I get that. And so someone looks different or speaks a different language, and they're getting treated in a way that wouldn't be consistent with the premise of Unruh Civil Rights Act. But how do we know? How does the person who's doing the bad act know what the person's status is? How do you prove that? I mean, after the fact, so somebody did something, we don't know what the, I'm just trying to understand.
So your question is, how would we prove that the employer, the business owner, was acting on the basis of immigration status?
Yeah, because they don't know what their immigration status is. I guess it's discriminating on the language or their looks or something like that, right?
It could be, but also could be very explicit about it. It could be, we think that you are undocumented and therefore I'm not going to sell you a lottery ticket. We think you're a day laborer and therefore you're probably undocumented and you can't shop at this Home Depot because of that. Sometimes it's made very explicit in the interaction.
I'm just thinking about how you'd apply it a little bit. I mean, obviously in that situation, the law is pretty clear. But in other situations where you say, well, I was discriminated against, and then you come up after the fact, if they didn't make that point clear. I'm just trying to think of it.
I mean, that's always the case in proving discrimination on any basis where it's not explicit.
Well, no, you don't know if somebody comes in with a yarmulke and you know, is Orthodox Jew, and you say no Jews allowed. That's usually pretty easy to determine. Or someone who's African American, and you say I'm not going to serve African Americans. That's easier to prove. Status is, you know, of all the hundreds of countries around the world, you know, it involves everybody, right? It involves people from Iran or people from Indonesia or from any place, right? It's the immigration status is immigration status. It's not just one part of the world. So how do you make that determination as otherwise? I think it's there. I just wanted to raise it in this discussion because I think it certainly could be played with a little bit. It's just the one area of the law when you look at these kinds of discriminations that's going to be a little bit more challenging.
Yes.
You know?
Probably true. Probably true. Thank you. All right, any opposition? Any opposition to this bill? All right, any further questions from members? Not Checha, but we have Senator Morlock has a question.
Senator Pan, I'm just curious. We've had 3 bills by Senator Yee, 600, 242, and 111. I'm just curious, how is your bill different from those 3 efforts?
Well, I would say is that you know that those bills were done in a different time with different leadership in governor's office, and I think that this issue certainly is one that we've seen. We know that the issue, the language of national origin, has not been sufficient to cover these forms of discrimination, and so I believe that the time that we should revisit this issue, and so that's why I authored this bill.
Thank you.
All right. Motion by Senator Leno. Senator Pan, would you like to close?
I respectfully ask for an aye vote. Thank you.
All righty. All discussion having ceased, Madam Secretary, this is due pass to the Senate floor. Please call the roll.
Jackson?
Aye.
Jackson, aye. Morlock? Anderson?
No.
Anderson, no. Hertzberg?
Aye.
Hertzberg, aye. Leno?
Aye.
Leno, aye. Monning?
Aye.
Monning, aye. Wachowski? Wachowski, aye. Morlock, no. 5-2.
5-2, that bill is out. Thank you very much, Senator Pan. Now let's go back to file item 5, unless there's anybody else you'd like to score some points with, Senator Way, so that you'd like to move ahead of you.
Just you, Madam Chair, so.
Oh, well, on that basis, I will take you up on it. Not at the moment, though I appreciate the offer.